Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. If you're studying for the bar exam, this case summary is one you need to understand cold. If someone buys your high-value item with a fraudulent identity and then sells it to someone else, who actually owns it? Today, we're breaking down the landmark case of Phillips v. Brooks Ltd to see how the law handles identity fraud and what it means for your business transactions. Alright, let's start with the real-world problem, a high-stakes scam that happens in person. This is where most business owners get caught off guard. In this case, a man named North walked into a jewelry shop and claimed to be a wealthy person named Sir George Buller. He wrote a check for a diamond ring and signed it with the stolen name. Because the jeweler believed he was talking to a reputable person, he let North take the ring before the check cleared. This highlights the danger of trusting identity without verification during a physical sale. After getting the ring, North immediately pawned it to Brooks Ltd for a fraction of its value. Brooks Ltd had no idea the ring was obtained through fraud and acted in good faith. This creates a legal tug-of-war between the original jeweler who was scammed and the pawn shop that bought the item honestly. Understanding who the law protects in this scenario is vital for anyone handling resale goods. Predictably, the check North used was worthless and bounced shortly after. By the time the jeweler realized the fraud, North may improve and the ring was already in the hands of the pawn shop. This is a classic bounced check scenario that still plagues private sellers and small businesses today. It forces us to ask if the original contract was ever valid to begin with. To understand the court's decision, we have to look at the legal framework of how contracts are formed when fraud is involved. The jeweler argued the contract was void because he only intended to sell to Sir George Buller, not the fraudster. In legal terms, if a contract is void, it never existed, meaning the title to the ring never passed to the fraudster. However, the court found that the jeweler intended to contract with the person physically standing in front of him, regardless of the name used. This distinction determines whether you can get your property back or if you just have a claim for damages. Because the fraudster lied about his name, the contract was deemed voidables rather than void. A voidable contract is valid until the victim takes steps to cancel it. The problem is that if the fraudster sells the item to an innocent person before the contract is cancelled, that innocent person gets to keep the legal title. This is a major risk for sellers who don't act instantly upon discovering a discrepancy. This Latin term means between those present. The court ruled that in face-to-face dealings, there's a strong presumption that you intend to deal with the person in front of you. Even if they lie about their name or status, the law views the physical presence as the primary factor in the agreement. This makes it much harder to claim a contract is void compared to transactions done through the mail or online. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. Knowing that the law might not protect you if you're scammed in person, let's look at practical ways to manage these risks. Never rely on a name or a check for high-value items without secondary verification. Ask for government-issued ID that matches the payment method and ensure the person's identity is verified through a third-party system if possible. In the Phillips case, a simple ID check or waiting for the check to clear would have saved the jeweler thousands. Modern businesses should use digital verification tools to prevent similar social engineering attacks. One of the safest moves is to implement a mandatory holding period for goods until funds are fully secured. Don't release high-value assets like jewelry, electronics, or vehicles until the bank confirms the transfer is irrevocable. Many sellers confuse a pending transaction with a completed one, which is exactly where fraudsters thrive. A clear policy on fund clearance can prevent the legal headache of trying to recover assets from a third party. Check your business insurance policy to see if it covers theft by deception or voluntary parting. Many standard policies exclude losses where you willingly handed over the item, even if you were tricked. Understanding your coverage limits helps you decide when to take extra precautions and when to require more secure payment methods like wire transfers. If your insurance won't cover a bounce check scam, you need stricter in-store protocols. If you find yourself in a situation where you've been scammed, here's how to handle the aftermath and when to call in the pros. If you suspect fraud, you may want to act immediately to rescind or cancel the contract. This involves notifying the police and attempting to contact the buyer to demand the return of the goods. By taking these steps quickly, you may be able to prevent the fraudster from legally passing the title to someone else. The longer you wait, the more likely the law will protect the next person who buys the item. The general rule is nemo dat quod non habet. You can't give what you don't have. However, Phillips v. Brooks is an exception to this rule because the fraudster did technically have a voidable title. If the contract was void, for example, theft without a contract, the fraudster could never pass title. Understanding which category your situation falls into is a complex legal question that determines your chances of recovery. When high-value assets and third-party buyers are involved, the legal fees are often worth the investment. A qualified attorney can help you determine if the contract was void or voidable and represent your interests against pawnshops or other buyers. They can also help you draft terms of sales that provide better protection against identity fraud in the future. Don't try to navigate title disputes alone when the law is this nuanced. That's the practical version of Phillips v. Brooks Ltd. The big idea is that in face-to-face sales, the law presumes you intend to deal with the person in front of you, making you vulnerable if they lie about their identity. To protect yourself, verify every buyer, wait for funds to clear, and act instantly if something feels wrong. If this helped you understand the risks of identity fraud in business, like and subscribe for more practical guides that help you protect your assets and make smarter commercial decisions. Share this with a study group or anyone preparing for the bar exam. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.